Hi, everyone. Harry here to talk about Judge Chutkan's denial of Donald Trump's effort to hijack and reconfigure the immunity proceedings before her and her grant of the DOJ's motion to file a hugely oversized brief from the normal 45 pages to 180 pages. And basically the status quo obtains, as the lawyers say. The DOJ will file its oversized brief of not more than 180 pages on Thursday, the 26th. Trump will respond October 17th. DOJ will reply October 29th, and then there will be a hearing almost certainly after the election. Although these filings themselves may provide a fair bit, it appears, of evidence to the extent it's permitted to be disseminated to the public. All right, quick review of how we got here. Supreme Court takes the immunity case, holds it for 9-some months, issues an opinion saying there is immunity for core conduct. For other official acts, there's presumptively immunity, but you can overturn it. For non-official acts, there is no immunity, and sends it back to Judge Chutkan to try to make sense of this basic hash, which it really is. In particular, the test for when presumptively immune conduct actually is non-immune is really head-scratching. But there you go. Judge Chutkan's the lucky district court, and DOJ, the lucky prosecutor that can try to figure this out. Now, it goes back to Chutkan, and she gathers the parties together and says, let's figure it out. Let's get a schedule together. Trump right away said, oh, okay, here's what we need to do. I've got all these motions to dismiss. Let's do them. And on immunity, let me file a motion to dismiss, and I'll just ride the train here, and we may arrive in the station at 2027 or so. DOJ said, no, Your Honor, look, the Supreme Court said you've got to work through immunity. That's what you should do. You should work through immunity. You should do that first. We know this case has another trip to the Supreme Court in its future. If we can, let's keep it to one trip and one trip only, meaning let us give you our entire analysis of what fits and what doesn't under the Supreme Court's holding. You can then decide, and then Trump can appeal. All right, and it's at that point that she agrees with the government and sets the briefing schedule. Then, yesterday, the government says, well, we also know why the government asked for an extension of time even to come to that hearing, because what they obviously were doing, the fruits of which we'll see on Thursday, are with going through the indictment line by line and trying to determine where they have evidence that they can offer, gets around the Supreme Court's immunity doctrine. That's what they included in a new indictment that they had a new grand jury issue, a superseding indictment. So they've tried very carefully to determine what will fly after the Supreme Court argument. But one, after the Supreme Court decision, but some of that decision's a little unclear, or more than a little unclear. And two, there's some evidence that I think they've decided they really need and it's worth taking a risk for. And that in particular is the evidence involving Mike Pence, whom Trump totally slapped around to try to get him to violate his constitutional duty under the 12th Amendment on January 6th and January 5th. So, okay, let us then, Your Honor, give you 180 pages. And the 180 pages are going to include its clear evidence. So it's not simply here's the allegation, but it's going to say, here's what the facts are. They start with, and Chutkan emphasizes as well, that the Supreme Court says this is a necessarily fact-bound inquiry. So they are going to just give her an avalanche of facts and legal argument to say, okay, paragraph 36, that involves non-immune conduct. Here's why. Paragraph 38 marching all the way through. And the arguments won't be simply, here's what we're alleging, but here is what the proof is. So in that sense, while much of this can be redacted, there is a prospect that the brief that is coming our way on the 24th will include information that Chutkan agrees to make public that will at least reveal the government's evidentiary hand for certain key allegations, and in that sense could immediately kind of enter into the political maelstrom of this election, with facts coming out and sworn testimony in the grand jury and the like that is really damning of Donald Trump. For that reason, as well as his general hand and strategy of always going for delay, you may see Trump, and this will be very telling, moving immediately to keep this from going forward. And he will argue, as he's argued in his motion to Chutkan, which was denied, to say, don't grant an oversized brief, that the mere surfacing of some of this material in court represents irreparable harm to him because of his electoral prospects. So he may say right away, we are in an immunity setting. The Supreme Court has said I have immunity in all these things, and you must determine up front before receiving any evidence, Your Honor, whether there are certain things that are immune, because if they're immune, even their receipt into evidence could violate the Supreme Court argument. Now, it's not really a cogent argument because the Supreme Court didn't talk at all about what kind of evidence could be public. It did talk about what kind of evidence could serve as the basis for conviction. But since his argument is going to have to do with avoiding the opprobrium, as he puts it, of facing these accusations, I think he can well mount some kind of argument before he is due to file his response to the government before October 17th, saying, stop the music, and if you disagree, Judge Chutkan, I'm going up to the Court of Appeals, and if they disagree, I'm going up to the Supreme Court, and even if that kind of motion fails, it eats up a lot of time. So when Chutkan denies his motion and makes it clear all he's trying to do here in opposing the oversized brief is represent the argument that already lost, namely he should go first and there should be certain discovery disputes that should be decided first. He says, though it really is not very cogent, that the need for a certain kind of presentation in the immunity setting is aggravated by the government's purported, but never demonstrated, discovery disputes, and also that makes the argument that immunity itself requires her to first hear from him and the like. So Chutkan first rules in her order today for the government. I'll give you your 180-page brief, rules against Trump, but then actually spends a few pages explaining why the arguments that he's represented. You need to do immunity before these discovery disputes, or the DOJ is breaking its own rule about activity before an election, which it is not. That rule is only about overt investigative moves like the serving of a search warrant. It's not only not a violation, but it's required. A court says, give me a brief on something. The DOJ has no policy, nor could it. It just tells it to respond to the court. Oh, sorry, we're not doing that because it's near an election. So this has, again, as she had said before, she repeats, this really has, nothing to do with what we're doing. And then finally, a really far-fetched argument that he made, did Trump, in the motion to oppose the oversized brief, is it would be tantamount, this 180-page brief, to a premature and improper special counsel report. Remember, the special counsel regulations require at some point that Smith do a report. They don't specify how long or short, nor do they specify what's made public, except that if Merrick Garland declines to any of Smith's decisions or overturns them, that has to be reported to Congress. That's got nothing to do with nothing at this stage of the litigation. And Chutkan says as much and says we need not address the substance of these claims. This defendant, Trump, does not explain how these putative violations, that's a legal word for even if, cause him legal prejudice, nor how the court would be bound by anything about DOJ policy. Okay, so where does this leave us? It leaves us with the government having what it wants, but also the judge. He's got a huge job having to figure out every single paragraph and having to do it at pains of being reversed by a very persnickety and immunity-happy Supreme Court. So she's going to need all the help she can get. And those 180 pages presumably will march through allegation after allegation, but also with supporting fact after supporting fact to argue why the superseding indictment is kosher under the Supreme Court's opinion, and most particularly why the stuff about Pence that remains in there. Remember, some things came out. The stuff about DOJ came out. The stuff about with discussions with White House counsel came out. But the Pence stuff stays in, and that's going to be the really most sort of red hot focus and argument why that can come in, and what essentially they're going to have to argue is, even though it might look like official policy, it isn't. I mean, official action, and in any event, we can overcome that presumption with a showing, as the Supreme Court said, that it doesn't basically undermine executive function and authority. So it's going to be a really big, no-holds-barred battle, and the immediate question, can Trump somehow get this up to the Court of Appeals and then the Supreme Court before the big battle is even engaged in Chutkan's court, or will the DOJ and Chutkan be able, as they hope, to have it be one huge hearing that goes through everything, and then and only then is it served up for appeal to the Court of Appeals and the Supreme Court. So stay tuned for that, and stay tuned for the government's oversights brief coming Thursday. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.